Welcome, ladies and gentlemen.
We're back.
Mr. Shaw, Miss Womack, Chapter 4. Let's do it.
Coming at you live.
Talking about civil liberties and public policy first, just covering the first three sections today. Again, we're going to talk about the Bill of Rights, how it's been applied to the states, distinguishing between the two types of religious rights protected by the First Amendment, and then differentiate the rights of free expression protected by the First Amendment. Let's do it. All right, so Learning Objective 4.1, trace the process by which the Bill of Rights has been applied to the states. So we're going to talk about the Bill of Rights then, and the Bill of Rights now, and then the Bill of Rights in the states. Take it away, Miss Womack.
Okay, so the Bill of Rights, we've learned previously that was kind of the compromise to ratify the Constitution. So the Constitution is ratified, and immediately they add in the first 10 amendments or the Bill of Rights. Most were wanting something like this that states the rights of Americans that the government cannot take away. Civil liberties are not absolute, it says, so it's kind of hard to understand. We say it's a Bill of Rights, but it's more like a Bill of Liberties.
Yeah, in a lot of ways, the civil liberties are protecting you against the government. Like, it's protecting you from
the government. Yes.
So, like the Second Amendment, the government cannot take away your right to bear arms.
Right, so it's a protection you have against the government.
Perfect.
So, and then we're going to talk about a lot in this entire unit that civil liberties have to kind of be balanced out. It's almost like, where do my liberties end and where does someone else's liberties begin? You know, I only have a certain reach to my liberties. I can't hinder the safety or the security of someone else by what I am doing.
Do we talk about social contract in this class? I feel like
maybe a little bit.
The idea behind the social contract that you give up some of your rights in order to have protection from the government.
Exactly.
It goes like this. So before the government, you could just go and kill anybody and nobody would be able to stop you. But now, because of the government, their right to life is protected from you. So now, sorry, you can't kill anybody. Well, I guess you could, but you got to go to jail.
Yeah, but like, I'm protected from it too.
Like, from bullets? Are the bullets going to stop?
Like the Matrix?
Oh my gosh, you guys are too young for the Matrix.
Yeah, you don't know about that.
Next! Look it up. Sorry, moving on. I can take it?
Sure.
Let's do it. Okay, so the Bill of Rights in the states are a lot of really intense court cases. The first one to talk about is Barron v. Baltimore, and that in 1833 they specifically stated that the Bill of Rights only applies to the federal government. They said that it doesn't apply to the states. That's insane. Like, states have their own Bill of Rights that are mostly similar to our Bill of Rights, but Barron v. Baltimore said that the Bill of Rights under the U.S. Constitution only applies to the federal government.
Yes.
Fast forwarding to Gitlow v. New York in 1925, this actually kind of fixes that.
Right.
Okay?
Overturns, in a way.
In a way. So the 14th Amendment basically says that all of the rights, all of the Bill of Rights, like all those things that are in there, they still apply to the states, because under the Reconstruction era, they like the southern states were specifically limiting African Americans' rights. So they had to pass the 14th Amendment to make sure that they declared everybody was a citizen who was born in America or naturalized in America, and that they have the same rights, and like those rights cannot be taken away if you are a citizen.
Correct.
Unless you break the law or something like that.
Correct. And so that takes us to the incorporation doctrine, which is just the idea that, again, the Supreme Court says the Bill of Rights do apply to the state. Sorry. So anyway, the Bill of Rights does apply to the states, and we get that through the 14th Amendment. Now, not all of the Bill of Rights have been incorporated or applied
to the states.
But most have. And so there's a couple charts coming up that'll show you exactly what doctrines within each amendment has been applied to the states.
Also, sorry, I can't spell.
Yeah.
My bad.
Supreme
It's
Court.
embarrassing.
Supreme.
I just wanted to spell it like it sounds. Anyway, we did skip due process clause. Make sure you guys know that. That is guaranteeing that persons cannot be deprived of life, liberty, or property by the United States or state governments without established legal proceedings happening. So we'll learn about the other amendments momentarily. Again, in class, we'll talk about those. Again, the Fourth Amendment, Fifth and Sixth, Seventh, and Eighth Amendments, those have to be applied, and that's known as due process. Those 5 amendments, those have to take place in order for you to be deprived of your rights.
Yes.
All right, so you see here, we'll talk about the date of incorporation. So, for example, freedom of speech was first incorporated in 1925 in Gitlow v. New York that we mentioned earlier. And so this is, again, we're not going to go through all of these, but you'll notice that a lot of these are where like these Bill of Rights are actually going to be applied to the states now.
Okay, notice before we move on that in this last one, 2010, we've talked about McDonald versus Chicago. Have we?
No, that's this unit.
Oh my God.
So we'll talk about it this unit.
We're talking about this unit. But anyway, so isn't it weird though that it wasn't incorporated until 2010?
Well, and it's interesting that because a lot more recently people care about their right to bear arms much more so than they did.
Very true, very true.
Even
true.
20 years ago.
Right.
All right, so moving on, you can see the Third Amendment. So no quartering of soldiers, that has never been incorporated. Also, not really a big deal.
No.
But they were so angry at the British for doing it.
Yeah, well, I would be too.
Bunch of jerks. Fourth and Fifth, again, all incorporated except for a part of the Fifth Amendment. The right to a grand jury indictment has never been incorporated. And all of the Sixth, not the Seventh. The Seventh Amendment is a lot like the Sixth Amendment, but it's just a civil trial, not a criminal trial. That's never been incorporated. And Eighth Amendment?
Yeah, the
Eighth Amendment, part of it.
Excessive fines.
The excessive fines and bail. Again, so that's never been incorporated, but that's not to say that it couldn't be.
Right.
Just, I guess the states have never really violated that, I guess.
Right, yeah, agreed.
Okay.
Okay, 4.2, distinguish the 2 types of religious rights protected by the First Amendment and determine the boundaries of those rights.
Let's do it.
Okay, so in the First Amendment, we know that it gives us freedom of religion, but there are 2 clauses within the First Amendment that we also need to know. They're very important. The first one is the Establishment Clause, and basically it just says that Congress shall not establish an official religion. Okay,
or favor any
or
religion.
favor religion. So Congress cannot take any action or make any laws that would be seen as favoring a particular religion over another one. An example of this is, in general, federal funding doesn't necessarily go to private religious schools, because if federal funds were helping to fund anything at a religious school, then it would kind of be seen as Congress favoring one religion over another. Okay. The second clause that you need to know is called the Free Exercise Clause. And it basically says that Congress cannot interfere with you freely practicing your religion.
And again, it goes back to your rights to practice any religion only go as far as when other people's rights begin.
Correct.
So if your religion that you say you follow declares that you need to sacrifice a virgin to, the gods, okay, you're not going to be able to do that.
Can't kill somebody.
Okay, because again, that would take away their right to life.
Correct.
So you get the idea that it's like you still that's always going to be important as we go through these Bill of Rights here. So Establishment Clause, we have a lot of these are the things that we're going to cover about the Establishment Clause. So you don't need to write these here because we're going to get them in the next couple slides. But we're going to cover education, religious activities in public schools, school prayer, evolution, and public displays. I was motioning; they didn't see it.
Sorry.
That's okay. All right, so let's start with education.
Here we go.
We're going to start.
Lemon versus Kurtzman.
All right, so this one says specifically that if you're going to get federal funds for education, it has to have a secular legislative purpose. Also, that it has to have a primary effect that neither advances nor inhibits religion. So,
Mr. Shaw.
Ms. Womack.
What is secular?
Secular, meaning that it is non-religious.
Thank you.
But really put me on the spot there. Okay? So the other thing is that, like, so basically, this is about a private Catholic school, or not. I'm sorry, I don't know that it's Catholic. It might just be any
Private religious.
any private religious school, and they are trying to establish federal funds, and they need to make sure that those funds are not being established or used for religious activities.
Advancing a religion.
Correct, because that could make the government look like it was favoring that religion, and that's not good.
Correct.
Okay, so this establishes what's known as the Lemon Test, and these are the 3 parts of the Lemon Test. I didn't mention
3-prong test is what it says in your book.
Write that down.
Prong.
You don't actually have to write that down. Anyway, the last part of the Lemon Test is that it can't foster an excessive government entanglement with religion.
Mm-hmm.
And so, again, if you were giving money to a Catholic school and they were using that to build a new mass, or like a mass, I don't know, what do they call it? Mass.
It's not a temple.
Room?
It's a
I don't know. The place where they hold mass.
It's a worship. It's a place of worship.
Well, that's my wife's going to kill me. Okay. Anyway, again, if they were using that to build a new center for mass, that would be bad because it would look like the government
Isn't it
was.
just a church?
But not in the school. They can't. It's like they're not going to have like a separate church inside the school.
Yeah, it's called it has a word.
Okay, we'll figure it out. Anyway, the next one is Zelman v. Simmons Harris, and that's going to uphold a state program providing families with vouchers that could be used to pay for tuition at religious schools.
Yeah. This is okay, though, I think, because they offer it to everyone, and it's your personal choice on whether you go to the public school that you pay taxes for already, or you can take state vouchers, and everyone has this opportunity in whatever state it might be to go to a private school.
Correct. So, like in this case, not every state uses a voucher program.
No.
And it's not like a requirement from the federal government,
No.
but it is something that really does come into play because then if you send your kids to this other school, you're not going to want to still pay taxes for the public schools.
Right. I think they do this in Michigan.
Sounds right.
I think it is. I think it's
I'll
Michigan.
believe you.
Okay, thanks. Moving on. Okay, so let's continue. Religious activities in public schools. So schools have to provide equal access for religious groups, meaning, here at Fort Smith South, we have FCA, Fellowship of Christian Athletes, and it's a voluntary before or after school group that meets, and it is religious-based. However, if a FMA, Fellowship of Muslim Athletes, wanted to form a group, that would absolutely be okay, and we would have to allow that because we're allowing equal access for all religious groups in the school setting. So,
like along the same lines, if a Muslim like a Muslim student needed to pray,
Yes.
like we would absolutely not be allowed to stop that from happening.
Right.
Okay. Again, since we are technically Missouri government officials, like that, we would get in a lot of trouble, and like the student would be able to sue us if we did not allow, or the school anyway didn't allow time for their prayers.
right. So scholarships and instruction, I think what we're going for there is instruction. We cannot advance a religion through instruction. We can teach about religions.
Correct.
You learn about religions, and world history most of the time. But we can't necessarily use, let's say, the 10 Commandments as rules to the classroom kind of a thing.
Correct. And I feel like scholarships, it's more like that we can't, you can't use federal funds or even state funds rather for a private scholarship
Right.
that is for, like, say, like done by the Christian athletes. Like,
Right,
again, going
right.
back there, they probably do a scholarship, but that can't have any federal funds attached to it because that would be them favoring one religion over another.
Correct. And then we get down to school prayer, and this is a very controversial issue. And so one of your required cases is called Mr. Shaw calls it Vital. I say Vitale.
And I think you're wrong.
And I think he's wrong. So anyway, this is a major Supreme Court ruling. And it says that a state, what state was it?
I don't remember.
Yes, no, it was a Oh, I can't remember.
It's okay. So basically, what happened was this school held a prayer before every single football game.
Yes.
And it was done over the intercom. Okay, and they pretty much essentially forced people to participate in this prayer.
They didn't make them, bow their heads and pray, but it was over the PA system before a football game.
It was required that it was recited.
Yes, okay. It was recited, and that people, if you were present, you were basically being forced to participate in religion.
Essentially.
Yes.
You'd have to plug your ears and go.
Right. And so the Supreme Court says that this is unconstitutional, that regardless of if you're actually saying or reciting the prayer, just being present and being forced to participate in religious activity is actually against the Constitution.
Again, because these schools are their government establishments.
Correct.
They can't, again, it's going to be seen as favoring Christianity.
Right.
If, again, assuming that's what the
prayer
was about.
Yeah.
That is going to be seen as favoring that rather than, and there's going to be all kinds of other students that have different religions, Jewish, Muslim, whatever,
right.
Okay, and they are going to be subject to that as well. So that's unconstitutional.
So another thing to note, though, is let's say the football team voluntarily on their own prayed maybe in the locker room before the game. If it was student-led, that's absolutely fine. But just since it was a public thing and it was over the PA and everyone was involved is why it would be seen as unconstitutional.
And there's a lot of schools that still do similar things, and they have found ways to get around that. And that's why it's so controversial, because people think that they should have that right to be able to pray before a game.
Freedom of religion.
Yeah, and so it even gets kind of into freedom of speech a little bit, like you are sharing your beliefs, expressions, what have you. Anyway, we'll talk a lot more about that in class.
Yeah.
But that is one of the first major cases that we have in this unit. All right, so the last part about Establishment Clause is about kind of about teaching evolution is the first thing. Originally, people, again, you probably learned about it in U.S. history. They talked about it's the Scopes trial, the Scopes monkey trial case. There was a Tennessee law that was specifically forbade anybody from teaching evolution, and they were trying to make sure that never happened. A guy taught evolution, and anyway, it was this huge debate. So now we're kind of trying to so we know that you can't really teach creationism in public schools. If you want to teach creationism, you have to go to a private school. That's fine to do it in a private establishment. But they are trying, again, a lot of states are trying again to start what's called intelligent design. And so intelligent design is essentially like a reworking of creationism. Basically, people think that there is no way that evolution happened all on its own, that there had to have been an intelligent being that was guiding evolution. So anyway, there's a lot of states, especially in the southern areas, that are trying to kind of push that back into public schools.
Right.
And then public displays. So you can't advance. You're basically you're checking and making sure that you're not advancing religion versus an actual historical purpose. So what's interesting about this, and it kind of gets into holiday decorations as well, with just think of Christmas. Hey, with Christmas, if you want to have a nativity scene, hey, that's not okay if you're on public property or public or government property,
right? Because
that would be seen as you favoring Christians or Christianity over other religions. But if you use other secular symbols such as Christmas trees, Santa Claus, snowflakes,
ornaments
in tandem with the nativity scene, then it's okay.
Yeah.
But again, that's on public displays.
Right.
And so again, the advancing, you want to make sure that you're remembering the placement of these things and where we're at is very important, because if we're in a private business, I mean, a lot of this stuff goes out the window.
And guys, remember that all of this is very gray. This is not black and white. This entire unit is going to have a very large gray area. It's not cut and dry. And the Supreme Court, on all these different cases, it could be the same topic and the Supreme Court could have ruled one way on one case and then a different way on a different case that is involving the same topic. And so it's very gray, and a lot of you guys are like, well, what about this and hypothetical that? And we don't have all the answers. We can just tell you what it's supposed to look like and what the Supreme Court has said on certain things. And that's all.
Well, and that's kind of why this unit is more interesting than all the rest.
Yes.
All right, so moving into free exercise.
Yeah. Let's do that. I'll do that. Okay, so belief versus practice. everyone can believe in something, right? But there's a difference between believing and practicing. So not all practices are protected. As Mr. Shaw said before, you cannot use like human sacrifice as a religious practice. Murdering someone is not okay. So you cannot violate the rights of others. You can't claim that you're using religious practice to violate someone else's rights. So in the case of Wisconsin v. Yoder, again, required case, 1970s, a couple Amish children were going to school. They go through 8th grade. And according to some sects, S-E-C-T-S, of the Amish religion, they want their children to go to school through 8th grade and then be pulled out. And then they think, well, we'll teach them whatever else they need to know. And, they're going to follow their religion. And that's just how it was. Well, according to the Wisconsin law at the time, kids are supposed to be in school until they're 16 years old. And in Missouri, currently, it's like 17 years old. You have to be in school. Well, the Supreme Court says that in this case, as a religious practice, it is okay for the Amish students to go to school through 8th grade and then be pulled out to do whatever it is they do later on.
Well, and a lot of the worry for the Amish was that if they go to high school, they're going to be exposed to a lot of new ideas, ideas that the Amish might not agree with. So they were really worried about. I mean, again, it's a small population,
right? And
so the more that, like, if they allow children to go to high school, like up until the age of 16, that could theoretically threaten their religion as a whole. And so they would really not be allowed. They would not allow. Again, it would look like they were favoring other religions other than the Amish if they did not allow them to pull out their kids after 8th grade.
Right.
The other one that was interesting, too, is the Employment Division v. Smith. I had mentioned this in my class. I don't know if you had talked about it in yours. These were like Native Americans that had they were smoking a hallucinogenic drug.
Peyote.
She got it. On the job. Again, that was part of their religion, and they were fired. So they sued. And the Supreme Court decided that it was okay to fire them because, again, your religion in this case was not. It was you were in a private business,
right.
And you like hallucinating on the job could be theoretically threatening to others and dangerous to others' safety.
And the Supreme Court was very specific in their decision. They said, on its own, the use of this hallucinogen as a religious practice is okay to do, but because you are violating the company's rules, they did have grounds to fire you.
Perfect.
Yeah. And then strict scrutiny. Ugh. Okay. So, kind of a difficult concept here. It goes along the lines of judicial review. Okay, and so if you're looking at judicial review, the idea that the Supreme Court or the federal courts can declare something unconstitutional, there's a couple different levels of judicial review, and strict scrutiny is the strictest level of that, basically. So if a case comes up that is involving something very pertinent, for example, discrimination against an individual, the courts are going to use strict scrutiny when reviewing this case or what law is being violated. Okay, so they're going to use the law, they're going to take it to the strictest degree when deciding that case.
So basically, the government then has to prove two things. The first thing they have to prove is that that law was the easiest way to accomplish that goal. Okay, that's kind of the second thing. It would make more sense if that was the second thing. The first thing then is going to be that the law was necessary, was an absolute necessity to be passed by the government. Right. And then the second thing is that they have to prove is that the law was the easiest way to get to accomplish that goal.
Yes.
And that's under strict scrutiny. And that's insanely difficult for the government to prove. Yeah. And it's only going to be proven in and I don't want to say rare, but it's going to make sure that we're trying to lower the amount of discrimination and improve the amount of fundamental rights that our citizens have.
Mm-hmm. Okay, free speech tolerance around the globe.
Specifically, you see here that the United States is the most tolerant of the free speech rights of religious extremists.
Yeah.
And that's really interesting. Again, we live in such a diverse country, and I would really this really kind of surprised me, when I first saw it.
I mean, looking at like Britain and France.
Right. Well, and
It
then
surprises me.
Well, and I mean, I guess the only one that really makes sense would probably be Germany at the bottom. Too soon.
4.3.
All right. So we're going to differentiate the rights of free expression protected by the First Amendment and determine the boundaries of those rights. Let's do it. So again, don't write these. These are the things we're going to talk about. We're going to talk about prior restraint, free speech and public order, obscenity, and then libel and slander.
I read that as obesity.
Way to go. Sorry, we're also going to talk about symbolic speech, free press and fair trials, commercial speech, regulation of the public airways, and campaign spending. Let's do it.
All right, here we go. Okay, so government actions that prevent material from being published, usually prohibited by the government. So
This is prior
restraint is the idea, and it is not allowed, but it's the idea that the government somehow takes action before material is published to censor that material. Okay, and in most cases, that is prohibited by the First Amendment. Obviously, we have freedom of press. Okay, in a court case, Neer versus Minnesota, not required case, but one that we do want to talk about, 1930s. The government applied unconstitutional censorship to an article from the New York Times. So the article, I think, had something to do with, I don't remember either. So anyway, the government applies censorship prior to the article being published. The New York Times, it goes to the Supreme Court. The Supreme Court says that the government cannot use prior restraint in most cases unless it has to do with national security. So if the New York Times was about to publish something that would hinder our national security or put it at stake for some reason, then the government can use prior restraint in that particular situation. We do also have to remember that prior restraint does not apply to students in a school setting. In a court case, Hazelwood versus Kohlmeyer, Hazelwood East High School in the 1980s, a principal censors the student published newspaper because they were writing about topics that the principal just felt like were too mature for the audience to read, and he censors the newspaper, and that goes all the way to the Supreme Court, and the Supreme Court says in a school setting, administration, teachers, principals, whatever it is, they do have the right to restrain or censor what is being published in a school newspaper or school setting.
So and I just wanted to clarify. I think that she had mentioned the New York Times, and this New York Times wasn't involved in the Neer versus Minnesota case.
Sorry.
That's okay, but I just wanted to kind of clarify
there.
that was it was in Minneapolis, and there was the person who was producing it, I believe, was named Neer, and they were suing because the state government had censored their article. And again, it's not important what the article was about, but they decided that it was unconstitutional to censor that, and that is called prior restraint, when they are kind of pulling articles before they're actually being published,
prior to publishing.
And the New York Times Company versus United States down here, that was about the Vietnam War.
Yes.
So they were basically, the New York Times published a bunch of classified material during the Vietnam War that made the government look really bad. And they're called the Pentagon Papers. And so basically the Supreme Court decided that it was okay for them to censor newspapers and the media when there was issues of national security involved.
Yeah.
Anyway, moving on. All right, so moving on to free speech and public order. So Schenck v. United States is required.
Yeah.
And it's also pretty interesting. This is the reason why you can't just go into a public place and then yell fire, or you can't say bomb on an airplane. Okay, this is the court case that is the reason why you can't do that. So Schenck was a guy who was a socialist. He was passing out pamphlets that said that you kind of discouraging people. This was during World War I. He was discouraging people from registering for the draft. He wanted people to not join the military campaign. So he was arrested, and he sued, saying that his free speech rights were violated. And so the Supreme Court stated that him publishing these pamphlets kind of created a clear and present danger for the United States government. If not enough people registered for the draft or avoided the draft, then we might be at a disadvantage.
National security issue.
Right, we might lose the war. Okay, so during war, basically a lesson to learn is that during war, all of your rights get thrown out the window. So anyway, that's the thing is so that's what this last bullet means, is it dangerous or merely inconvenient? Were we fighting? Did we really have a good justification for fighting in World War I? And so they didn't want to answer those tough questions to Schenck. So his conviction was upheld. But again, now that's why you can't, you can't you have to keep the public safe first.
Yeah.
Okay, and that's kind of why your rights don't really apply there.
Yeah. And then we moved on to anti-communism. So during the communist scare,
Red Scare.
The Red Scare, there were, I guess it's a group of people who were
advocating
to overthrow the United States government. And so the government passes what's called the Smith Act in 1940 that makes it a criminal offense to advocate for the violent overthrow of the United States government.
I think that was actually so. I think it was in Ohio, wasn't this? Because I think that aren't these two related? Brandenburg versus Ohio and Smith Act.
I can't
No,
remember.
maybe not. I might be connecting two different things.
Too many court cases to keep track of. We
So
need notes.
We should have notes.
We should.
All right. So the last thing is about the imminent lawless action. So Brandenburg v. Ohio was a KKK leader was giving a speech, and he was arrested for that speech under this Ohio law that prevented talking about communism or just really anything that was anti-government.
Yeah.
He sued, and they actually, I believe that I'm not exactly sure how they ruled, but what they're saying is you have to be sure that what you're saying is going to be able to create lawless action, imminent lawless action. So if you are just speaking and you are encouraging people to riot and loot places, that is illegal. But again, the government has to be able to prove that that your words were directly going to cause that imminent lawless action.
Yeah.
And that again, the Brandenburg v. Ohio isn't required, but we just kind of wanted to make sure that was understood.
Yeah.
With again, so your free speech, you can't really just talk about anything you want. You have to make sure that you're not going to cause riots. That you have to be careful with that.
Correct. Okay. So then we move to obscenity. Roth versus the United States in the 1950s, not required. But it basically establishes that obscenities in public are not necessarily constitutionally protected. But the question is, what is obscene? And that is the biggest problem or the biggest issue. And the Supreme Court really, there's no way for them to decide what is obscene. Because, artwork, for one, could be obscenity to another. But just as a general rule, the Constitution doesn't necessarily protect obscene material or whatever it might be in public.
And so they're always going to look at where the action took place. So that's why if the same thing happened in, say, Texas versus California, those are two vastly different states, and they're going to look at it and say, okay, in Texas this might be seen as obscene, but in California maybe it's not so much.
Right.
Okay, and so they have to take the place of the action into account.
And the time period.
Yeah.
You got to think about the time period. In the 1950s, many more things are going to be considered obscene than right now.
That's true.
Yeah.
Wait till the 60s.
Yeah.
Miller v. California. Oh, prurient.
Prurient.
Huh. All right. So Miller v. California. It appeals to prurient interest. So what's interesting about that is that so something has to be patently offensive. Okay, and so basically in order to be obscenity, okay, it has to be patently offensive, but again, who determines what's offensive?
What is offensive?
And then it has to also lack serious literary or artistic value. But again, that's going to look different to different people.
Right.
Again, average people, local standards, that's kind of what we were getting into earlier with Roth v. United States, is that, again, the place and time that it occurs is going to be very important to the case.
Right. And so that kind of takes us to the idea of pornography, adult material, adult content. Some people are going to see those types of things as offensive and others are not. And so, again, the Supreme Court kind of holds out on saying this is what we define as obscene because it, again, is subjective.
Again, going back to like the prurient thing, that literally means like when you are encouraging like sexuality or like adult content, and that is going like we don't really know what that looks like,
right?
And so it's
different to everybody.
That's why these cases are always going to be like, I would never want to be a Supreme Court judge.
Yeah,
like
difficult.
It sounds awful. Like, okay, what's obscene in this
lifetime
case?
appointment though?
You know, they get paid a lot too.
Yeah.
Maybe we're in the wrong profession. Oh well. All right, so going back to libel and slander, we have to know what defamation is first. So this is the action of damaging the good reputation of someone.
Yes.
Libel is when these lies are written. Slander is when they are spoken. And the standards for conviction are very high, especially for public figures. Public figures, they have to prove, again, going here to the next one, in New York Times v. Sullivan in 1964, they decided that the person who is doing the accusing had to prove that whoever was doing the lying was being intentionally malicious. And that's really hard to prove.
Yeah.
I was thinking of the Kathy Griffin with the
Donald
Trump
and she had his severed bloody head. But it was fake. It was a fake head.
And so again, Donald Trump would have to have proven that she was trying to be intentionally malicious. So the problem with that is that she's a comedian.
Yeah, and she was saying, I'm just being funny.
Yeah, I'm just trying to get a laugh. I mean, that's a pretty weird,
weird
attempt, but weird. I mean, it's not our job to judge.
Right.
Anyway, so that's why, that's kind of the difference. That's why we're talking about.
She lost a lot of work because of that.
Oh, I believe it. I mean, I'm not going to hire her.
No.
Maybe.
Where are we at here?
Sorry, we're done with public figures. We're on private
individuals. Okay.
Got it. It's a lot easier. Sorry, I was on a roll and I just stopped.
I'm sorry, it was my fault.
It's okay. So private individuals, actually, it's a lot easier for people to prove libel and slander if you are a private citizen.
Yeah.
So all you have to prove in that case is that there were defamatory falsehoods. And you have to prove that those who made the statement were negligent. So, for example, if somebody accused me of like slapping kids in the face in class and they were intentionally trying to get me fired, okay, that would not, like, again, that's libel or slander,
right?
Okay, depending on if it's written or spoken. Okay, so again, if they knew intentionally that it was false, they were trying to get me fired, that is going to fall under libel.
What were
and
the
slander.
intentions behind the claim?
Correct.
Is what they have to kind of take into consideration.
Correct. But again, for public figures, it's a lot harder to actually get a conviction on libel and slander.
Yeah. Okay, so then that takes us to symbolic speech, and there's a couple different cases here that you need to know. Examples of symbolic speech. First is going to be a case titled Tinker versus Des Moines. These were a couple high school students in the 1960s during the Vietnam War. They are siblings. They wear black armbands to school to basically silently protest our involvement in the Vietnam War. They were suspended for doing so. They end up suing the school district, and the Supreme Court says it is a silent form of protest. It was not really affecting the activities in the school day, and that the students were okay to wear those armbands. Okay, it's considered symbolic speech. Another court case that you need to know is Texas versus Johnson. And this happened when a guy burned the American flag and I assume was arrested for it and probably sued the government. And they say, actually, burning the United States flag is a form of symbolic speech. We are protected under the First Amendment for doing that. Another example of symbolic speech is marching in a parade.
But you got to be careful with parades because if it's a private organization
Right.
putting it on, they can choose to exclude people.
Right.
Okay, and again, it's almost like kind of protecting the people who are putting on the parade.
Right.
So, like for example, we didn't include the case, but there was a case of a St. Patrick's Day parade, and they excluded an LGBTQ like group from their parade, and the Supreme Court said that was okay because that was a private organization putting on the parade.
Right.
They have since allowed them to be in the parade.
Yeah.
Just so you know.
Right. And then we get to limitations. So burning a draft card. So let's go back a little bit. A draft card is something that, let's say, just for example, during the Vietnam War, all young men that were entered into the selective service had to carry a draft card with them at all times as part of just a government document that they had. They legally had to do that. So anyway, to protest the Vietnam War, some people would burn their draft cards. The government comes out and says that is illegal because it, number one, is a government issued document, and number two, legally, you were supposed to have it on your possession or on your person at all times.
And again, they're trying to find draft dodgers because
Right.
if people got their birthday called, they had to go and enlist, and if they didn't do that, then that is illegal. So,
Right. Yeah. And then also limitations to symbolic speech, threatening. You can't you cannot,
nice
say you're going to bomb the school or anything like that. That would be very much illegal to do.
And we've seen now, like, a lot of people don't really understand. Like, it doesn't have to be even like an overt threat. Like,
Right.
again, you can talk about like Snapchat and people just like having conversations. Like that is, I mean, we've had that happen even in our school. Like that's and like you have to be really careful with what you say, because once what you say limits rights of others or it could endanger others, that's no longer your right.
Right.
I said that kind of cool. That was nice.
You did.
Okay. So next up is free press and fair trials. So the question is, can press coverage compromise the right to a fair trial? So the idea here is that, like, Michael Jackson, and this is what your book mentions. I don't know why that's the most important one.
We don't know why.
But Michael Jackson, you guys know who Michael Jackson is, I assume. He was accused of child molestation in the early 2000s, I want to say. And so he, anyway, was getting all kinds of negative press coverage, and basically it was all really bad against him. It made him look really bad. And all of the people that were of the jury were going to decide his case, and they had access to the press. And so that was really like, what can we do to kind of fix that? We don't want them to be unduly influenced by the press in this case.
It allows for bias to be applied in, the jury is making a big decision on this guy, whether he's going to jail or not. And if the jury have already been exposed to all this negative media or negative press about Michael Jackson, they're already going to have like a preconceived notion of him. And so that the question comes in then, where does freedom of press actually end?
Correct. And so one thing that they do is they actually will sequester juries, and that means that they basically take everything away from them. They can't have a phone, they can't have a TV, telephone at all. There's these things called telephones that when you
they have a cord
with numbers on them, and then you press the numbers and it calls somebody, and that's all it's supposed to do. It's amazing. Anyway, so that's what's sequestering them, and that is to kind of keep them away from the undue influence of your peers, of the media, anything like that. That they want you to make the best decision possible, only based on the evidence in front of you. Next up is Zurcher v. Stanford Daily in 1978. I almost said 1798. I might be dyslexic. Okay. Anyway, the journalists, basically this decided that journalists cannot withhold any evidence. So a lot of times in like crime shows and stuff like that, you'll hear people talk about, my sources are confidential. Okay. Journalist privacy or something stupid like that. They can't do that. If journalists are basically, if they are found to have evidence, they have to give that to authorities, or again, they could be held in contempt of court, I believe.
Right.
So again, they are definitely subject to search warrants, and this basically is just going to say that they have to provide any evidence they have. They can't they cannot do withhold any of that from the police. Again, that's not required though.
All right. Commercial speech and regulating of the public airwaves. So this takes us to, and we've kind of learned about the FTC before, just with like bureaucracy. But what does it look like when it comes to advertising? So the FTC prohibits certain things from the public to see on the airwaves, or maybe it's the television, the radio, whatever it might be. And so an example of this is, like I told Mr. Shaw yesterday, that in commercials, like alcohol commercials, right? These companies are promoting their alcoholic beverages. Well, if you ever pay attention to them, you see the actual can or bottle or whatever it might be, but you never see anyone actually consuming the alcohol or the beverage inside the can. And that is something that the FTC is going to regulate. They put regulations on that, and they say, we can't show that to the normal public. So that's kind of a limitation to press.
And that's the same reason why you can't show. They decided that there's no smoking commercials, like
right.
no tobacco
no more
commercials
advertising
at all.
of tobacco.
And that was the Federal Trade Commission that did that, because again, a lot of it has to do with children.
Yeah.
Like what you'll notice is that
right.
if children are able to hear something, then they're going to able to hear or see something, they're going to be really restricted in what you can say. That's
right.
why, like when you go to like late night TV shows, they can actually they have a lot more freedom,
right.
because kids are probably asleep.
Yeah, if you look at like Comedy Central later at night, they say and do more controversial things, and things that would not be allowed to be done, like maybe in prime time.
What's that? I just have Netflix.
Oh yeah, there's a thing called Comedy Central. It's a show.
It's on the telly.
So anyway, the FCC also regulates some of that stuff. And again, it really does revolve around if children are present. And that's why, if you pay for like satellite radio, for example, and you listen to Howard Stern, he's a talk show host. I don't know if you guys know who that is.
Very vulgar.
Anyway, very vulgar.
Okay.
It's okay for him to do that on satellite or on cable, because you're paying for those services. It's not just something the public can turn on and view.
Mm-hmm. I think the book mentions George Carlin, very famous comedian.
Yeah.
He famously claimed about words that could not. He had a whole joke about the words that can't be said on the airwaves. The New York radio station aired it, and the FCC came down on him hard because they can't say that. Again, they have regulations against that. Again, they don't want children to hear those words, those things that might influence offend them, or it might lead them to a life of crime.
Right.
I don't know. All right, so I believe this is the last one. Is this the last one? It is the last one. All right.
Yes.
So
46 minutes, baby.
Campaign spending is a really big issue, and we're going to go way more in depth in this later. So we're not going to go into it too far now, but it's important to know that your campaign spending, like the money that you donate to someone running a campaign, that is considered speech. So the first one that we need to know is the Election Campaign Act of 1971. And in Buckley v. Vallejo, not required, in 76, they decided that spending money to influence elections is protected speech.
Yes.
So if I was to spend money or give money to a candidate, that is me exercising my freedom of speech.
Right. And this kind of comes up because and especially now, we see these large corporations donating gobs of money to certain presidential candidates or congressional candidates or whatever it is. And some people say, that is unfair. Just because they have so much money, they're going to have much bigger influence on this campaign. But the Supreme Court does say that donating to certain campaigns is protected speech.
So that leads us to the McCain-Feingold Act of 2002. This is a really monumental law that was passed. It essentially banned all soft money contributions. So there's hard money, soft money. Okay, hard money is cold hard cash. Soft money is things like perks, things like gifts, anything like that. So things that it's money that is spent, but is not necessarily it's not cash.
I'll let you use my private jet to travel the country to campaign.
Sure.
Something like that.
Perfect. Okay. Or maybe I'll donate a car to you or something like that. Something that is going to have like your poster, your face on it to help you with your campaign.
Right.
Okay. So it also bans certain advertising. Again, that's not as important for you to know quite yet, but we'll get into that
It's advertising
later.
within a month of the campaign or the month of the election. It's stuff like that. It's weird regulations.
Last thing is Citizens United versus the Federal Election Commission. Guys,
this is required.
It's required, and it's the biggest nightmare you'll ever have in your entire life. So for what you need to know now is that campaign contributions are protected speech, and they decided that they basically overturned part of the McCain-Feingold Act, and there are now no limitations on what corporations or people can donate to people who are campaigning.
Soft or hard.
Hey, and that's really, I mean, that's where we're at. Again, it's going to be, and there's a lot of people who think that's ridiculous. They think that these corporations are now having way too much influence on these candidates. And so we'll talk a lot more about that in the last unit, but we wanted to at least introduce it now. Guys, it's been a wild ride.
Sorry it was so long, but at least you have a week.
Hey, you're the best around. See you next time.